Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sunkara. This video relates to Section 306 of the Indian Penal Code, that is abatement to commit suicide. Simply to say, mere scolding a student by a teacher or by a lecturer, mere scolding a student by a lecturer will not amount to abatement to commit suicide. This is stated by Honorable Supreme Court of India, 2 judges bench, Justice Ahsanuddin Amanullah and Prashant Kumar Mishra. In the case of Thangavel versus the state, of course state is represented by the Inspector of Police. SLP number 9999 9999 by 2024, decided on 22nd May 2025, wherein Honorable Supreme Court of India set aside the decision given by the Madras High Court. Actually, Madras High Court refused to discharge the accused from the case under Section 482 CRPC. High Court held that yes, it is an offence under Section 306, that is abatement to commit suicide. How can you scold a student? That is the opinion of the High Court, but Supreme Court said no. As a teacher, he is having the so-called parental authority. It's called quasi-parental authority. The teacher should give warning. The student should warn, the teacher should warn the student. Otherwise, there is no limit for it. Anyway, let us understand the case law. This relates to crime number 1 by 2024. First one. 1 by 2024 under Section 306 IPC, read with 174 CRPC, and the investigation was done by CBCID. That means there was a lot of commotion in this incident. 174 CRPC you need not bother, because 174 CRPC is a procedural law where if anybody dies under suspicious circumstances, if anybody dies other than under natural circumstances, the inquiry should be done by normally the Tahsildar, by the police. Right. Here, the main allegation against Thangavel is he is the correspondent and he is also in charge of running the hostel. Actually, he is running the school, and on the particular day, he scolded the deceased boy. Why? Because another boy of the same class gave a complaint against him. Of course, it's a petty complaint. Since it's a petty complaint, this man scolded him and asked him to set right his behavior. But the deceased student felt ashamed. He went into his room, locked it from inside, did not come out. Ultimately, on the next day, when the people broke open the lock of the hostel room, they found him dead by hanging himself to the hostel ceiling fan. Very pathetic situation for the parents, because parents, తల్లిదండ్రులు పిల్లవాడు చదువుకోవాలని చెప్పి హాస్టల్లో చేర్పించి మీ స్కూల్లో చేర్పిస్తే అల్టిమేట్లీ అతను సూసైడ్ చేసుకోవడం ఏంటి, మీరే దానికి కారణం అని చెప్పి వాళ్ళు వాపోయారు, వాళ్ళు కేసు పెట్టారు. కేసులో తప్పేమీ లేదు. Normally the police have to register case under 306. Ultimately, it is for the court to decide. Right. He locked him, he hanged himself to the fan with a nylon rope. Right. And actually, why this man has scolded him, the appellant has scolded the student, that the student should not repeat the offense and to maintain peace and tranquility, and there is nothing personal in that. So, even in the FIR also, even in the investigation also, no other role has been attributed to the so-called appellant Thangavel. And actually, when the matter has come to the notice of the Supreme Court, they wanted to hear the version of the father. Tandri garu emantarani cheppi Marimuthu father's name. So he was also given a notice, but he did not attend the Supreme Court. The reasons may be so many. We don't know the reasons. He may not be interested. రకరకాల కారణాలు ఉంటాయి, రాలేదు. So in that absence, the version of the deceased was not available. Despite service of the notice served on him, Marimuthu did not attend the proceedings. Right. Now, findings of the Supreme Court. Supreme Court, we find that it is a fit case to interfere. It is a fit case to interfere, as no normal person could have imagined that scolding would result in such a tragedy. Teacher అన్నాక తిట్టుకుని ఉంటాడా? అయ్యగారు నాకు పంతులు గారు అంటారు, డెఫినెట్లీ would have scolded him. కానీ they did not expect that it would result in the tragic death of the person by committing suicide with a nylon rope. Here, the important point is 306 law. Aggravation, instigation, provocation, this all should be there. సహజంగా మనం 306 కేసులో ఆడవాళ్ళు చనిపోయినప్పుడు, వివాహిత చనిపోయినప్పుడు పెడుతుంటాం. నువ్వు చచ్చిపోతే మా అబ్బాయికి రెండో పెళ్లి చేస్తాం, నువ్వు ఉన్నావు, నువ్వు పోతే కానీ మాకు బెటరు, నువ్వు చస్తే కానీ బెటర్ అన్నాడు. Those words, they attract the so-called abetment to commit suicide, not scolding. Right? And here, there is no mensrea. No mensrea can be attributed to the appellant for abetment of suicide. Where is it? నువ్వు చేస్తే పోతురా అని చెప్పి ఎందుకంటాడు ఇతను? ఈజ్ అ టీచర్, ఈజ్ అ బాయ్, రిప్రమైండింగ్ ఈజ్ క్వైట్ కామన్, ఆర్ వార్నింగ్ ఈజ్ క్వైట్ కామన్, స్కోల్డింగ్ ఈజ్ ఆల్సో క్వైట్ కామన్. మమ్మల్ని అయితే కొట్టేవాళ్ళు చిన్నప్పుడు. సో the court said to prove a case of abetment suicide under section 306 of the Indian Penal Code, it is essential to prove the elements. What are the essential elements? Like provocation. Number one, provoke చేయాలి. నువ్వు పోతే కానీ మాకు బెటర్, ఎందుకు నువ్వు బతికుండి, పిల్లలు పుట్టినమ్మా ఎందుకు, మా వాడికి నువ్వు పోతే వేరే వాడిని చేసుకో, ఇట్లా మాట్లాడుతుంటారు సోటి పాటి మాట, మేబీ అతలు. ఇన్వెస్టిగేషన్, అబెట్మెంట్ కమిట్ సూసైడ్, ఇన్వెస్టిగేషన్ కూడా చాలా చాలా ఇంపార్టెంట్. ఇదే చాలా సందర్భాల్లో అతను ఎవరు, అతుల్ శ్రీవాసరావు గారు గుర్తురాట్లేదు, మర్చిపోయాను, బెంగళూరు టెక్కి, ఈ కమిటెడ్ సూసైడ్. అతని కేసులో వైఫ్ ఏదో కొన్ని లక్షలు అడిగింది, కోర్టు తిరుగుతున్నాడు, నార్త్ ఇండియాకి వెళ్ళినప్పుడు అసలు మీరు ఇన్ని అడిగితే నేను చచ్చిపోవడం బెటర్ అని చెప్పి అంటే, సరే నెక్స్ట్ వాయిదాకి వెళ్ళినప్పుడు వాళ్ళ అత్తగారు ఉంది, ఏమయ్యా ఇంకా చావలేదే, చస్తే పోయేది కదా అన్నట్టు. దట్ ఈస్ ఇన్వెస్టిగేషన్. దెన్ ఇంటెన్షనల్ ఎయిడ్ ఇన్ కమిటింగ్ ద యాక్ట్. సో without all these things, without proof of all these things, no offense is made out. Therefore, quashed by using Article 142 of the Constitution of India. Anyway, High Court is authorized to discharge under Section 482 of the CRPC. Presently, I think it is 528 of Bharatiya Nagarik Suraksha Samhita. So, as regards abetment to commit suicide, is a very good case. This shows the mental attitude of the child. No mensrea can be attributed to the headmaster or the correspondent. Good case law, read it and enrich your legal knowledge. Thank you very much.